Good afternoon, everyone. My name is Joaquin Torres, and I'm your elected Assessor-Recorder here in the City and County of San Francisco. And I'm so pleased that you've joined us for our second presentation of the 2022 Family Wealth Series, which focuses on understanding homeowners associations. If you joined us last week at our webinar about fair appraisals, welcome back. First, I want to take a moment to give a special thank you to the San Francisco Public Library for helping us promote this series with all of your patrons. Now, as you know, my office of the Assessor-Recorder is fundamental to securing funds for public services. We at the Assessor-Recorder's office ensure the city's financial resiliency, but beyond that, we want to see you as community members thrive as well. And that's what this Family Wealth Series is about. First, we talked about securing a fair appraisal. Then today, we're talking about understanding homeowners associations. Then next week, in our final presentation, we're going to talk about foreclosure prevention. All of these topics reflect my office's commitment to fair property taxation, racial equity, and of course, our commitment to support diverse communities to ensure that home ownership is within reach of everyone. Why is that important? Because racial prejudice and bias continue to corrode the real estate sector and city governments, as they do society at large. Just look at the research. It shows disproportionate impacts on communities of color, most often wherever you look. Nationally, the median white family holds 8 times the wealth of a typical black family, 5 times the wealth of the typical Latino family. That's a disconcerting statistic that speaks to the need of homeownership programs and resources for our communities of color. This reality underscores the urgency and importance of promoting as well a culture of racial equity here at my office of the Assessor-Recorder. Internally, as we do our work, and then externally, as we engage with you and community through our educational programs. The city as a whole is working so hard to lower barriers to homeownership through numerous housing programs that have expanded under the leadership of Mayor Breed. And this past year, I wanted to hear directly from you, San Franciscans, about what resources you need to ensure your future generations can remain here in San Francisco. Our community engagement has taken us all around the city. Neighborhood meetings, local library branches, street festivals, resource fairs. Our programs are designed intentionally based on your feedback. We've heard from you about so many issues. Home ownership aspirations you may have, questions about transferring your home to loved ones, the need for legal resources for homeowners, and for today, the pros and cons of being part of an HOA, a homeowners association. So today's presentation, understanding those associations, you're going to learn about the nuts and bolts of being on an HOA, your homeowner rights, and how to avoid excessive costs and wrongful foreclosure. If you volunteer on a homeowners association board, I just want to say thank you so much for your service. You know that there are many rewards and a few challenges too. Some residents may have individual demands and concerns. Some of your board members may have a hard time agreeing. There is also the critical need to manage a strict budget and do so carefully. And that's sometimes just the beginning. With all of the community's needs, being an active board member can seem at times a little daunting. We know today's presentation, and we hope it does, help you steer your community and yourself in the right direction. We've invited some of our key collaborators on our journey today, including housing and economic rights advocates. They're also known as HERA. They're a not-for-profit legal service and advocacy organization that's dedicated to helping Californians, particularly those most vulnerable, in their effort to build a safe, sound financial future for themselves, free of discrimination and economic abuses in all aspects of household financial concerns. And we're very lucky to have with us today HERA Senior Attorney, Gina DeGiusto. So please feel free to type in your questions for Gina in the question and answer box. Thank you again to Dave for joining us. So with that, take it away, Gina.
Hi, everybody. Thank you for participating today. I want to make sure that everybody has gotten to the correct rooms for their interpreters, and we're going to go ahead and get started with the presentation. My name is Gina. I am an attorney at HERA, and I've been with the organization for about 10 years now. And I largely work on homeowners association cases in the office. Today, I'm going to cover a lot of the basics about how homeowners associations, or HOAs, are structured, some common questions that I get asked from clients. I will be talking about assessments, meetings. So a lot of common questions I get asked from callers. I will say I am going to hold a question and answer session at the end of this presentation. So if you do have questions, please put them in the Q&A box at the bottom of this screen. And I would ask, if you have questions that are very personal or particular to your individual situation, I would say, instead of sharing those in the question and answer box, I'm going to be sharing our contact information, our organization's contact information at the end of the presentation. Feel free to call in and get a one-on-one individual session with one of our attorneys so that you can have your personal information kept private. So for the Q&A session, I would ask for more general questions, things that can apply to everybody as a group. And then, like I said, for more personal questions, please contact HERA. Our services are free, and we're happy to give you a one-on-one consultation. So with that, I'm going to have Clara go ahead and move on, and let's get started with our presentation. So the first thing that I like to talk about with homeowners who have homeowners association questions is first how HOAs are structured and who the common players are. Because not everybody who moves into a homeowners association necessarily understands who they're communicating with, who has the right to make decisions at the HOA. And I just want to make sure that everybody understands these basic rules. So first and foremost, if you live in a homeowners association, you should be aware that there should be an HOA board of directors. These are members of the association who have volunteered their time to be part of the board. They are elected by the general membership. And this board of directors is the entity that makes the decisions on behalf of the homeowners association. So if you have questions about the governance of the HOA, if you have particular issues as a homeowner, at the end of the day, it's the homeowners association board that is going to make the decision on what is going to happen with the HOA or what is going to happen in your particular case. Now, typically, most homeowners don't have one-on-one conversations with the board of directors. More likely, when they have issues with something that's going on in the association, they usually call a property management company. Now, not every homeowners association has a property management company. Sometimes HOAs are very small, but a lot of larger homeowners associations do have and have hired a property management company to help handle the day-to-day business of the association. So for example, it's usually the property management company that's been hired by the HOA that sends out notices to the membership, that is available on call if there's some type of issue. Let's say there's some type of emergency. Usually it's their office that fields those calls. If the homeowner needs to contact the HOA board members for whatever reason, let's say they want to meet with the board, usually they submit those requests through the property management company. So oftentimes, homeowners are very familiar with their property management company. That being said, it's not the property management company that runs the HOA in terms of making decisions. So sometimes homeowners get frustrated because they think that they're asking for something from the property management company, thinking they have the right to make certain decisions, when ultimately that decision is done by the board of directors, because the property management company is just an agent of the board of directors. So if you have something, let's say you have some type of dispute or some issue, and you would like a decision on that, it's not the property management company you should be asking for permission, it's the board of directors. So just make sure to understand that relationship. If you need something direct, a letter to the board of directors, you can send it care of the property management company. The property management company will facilitate any necessary meetings, but at the end of the day, the decision is up to the board. You might also realize as a member of the HOA that the Homeowners Association oftentimes has an attorney on call or available to the Homeowners Association, depending on what is going on in the HOA. If there's a legal matter or a legal dispute, sometimes the HOA will hire a firm to represent the HOA to handle these legal matters. Again, the HOA attorney is just an agent of the HOA working on behalf of the association, but sometimes legal guidance is needed for the HOA. If you are one of the unfortunate individuals who might be struggling with their HOA dues or in some type of delinquency with the HOA, you might be familiar with the fact that many HOAs can hire debt collection companies to go after and collect on delinquent balances owed by homeowners association members. So sometimes what happens is we will get calls from homeowners who have fallen behind on their assessments or they owe money to the HOA, and they start receiving notices or calls from various collection companies, and they're not entirely understanding why this separate company is contacting them about their HOA account. And the way it works is that the HOA board hires the collection company, and then once someone has fallen behind, they assign that account to the collection company and try and channel communications about the collections account to that company. The account is still owned by the HOA. The ultimate decision of what happens with the account is still decided by the board of directors, but the debt collector is now taking over that file and managing the interactions between the HOA and the homeowner, the member of the homeowners association. So sometimes you will get collection notices or be contacted by a debt collector if you're behind on your HOA dues or on your HOA account. And then, of course, there's all the homeowners. They are members of the association. If you are a member of the association and you're on title to the property, then you will likely have voting rights and get to participate and have say over what happens with the homeowners association. So these are the different layers of the association. It's really just important to understand that the board is kind of the ultimate decision maker. And then under that umbrella, they hire different companies, management companies, attorneys, collection companies, different agents to help keep the HOA running. The other common question I get asked is not just who does what in the association, but also what are all the rules? Because if you live in a homeowners association, you probably realize there's a lot of rules to follow, and it's hard to keep everything straight. So I'm going to go over kind of all the rules that govern an association, starting with the covenants, conditions, and restrictions. We call them CC&Rs for short. These are rules that are recorded with the county recorder's office. So when you bought the property, you should have been made aware that your property was in a homeowners association and that there were certain CC&Rs that govern your particular property. Those rules will tell you basically the what of the association. It will explain if there are any property use restrictions in the association. It will lay out the rules for any disciplinary hearings or issues if there's violations of the rules. The CC&Rs lay out rules about the assessments of the association, when they can be increased, by how much. Those you will find in the CC&Rs. Then you have the bylaws. The bylaws are kind of the how of the association. These are the rules that tell you when meetings are going to be held, instructions on elections, the general governance of the homeowners association. That's the type of information you're going to find in the bylaws. Those are not recorded with the county. But a copy of each of these items, the CC&Rs, the bylaws, this is the type of paperwork that you should expect to receive a copy of when you first move into the association. If you can't find your copy of these rules, or you don't know where they are, or maybe you just happen to not receive a copy, I strongly recommend that you ask for a copy of these documents from your association, because you want to make sure that you understand what's in the CC&Rs and the bylaws. Because the fact that you live in the property and they're recorded and they're part of the association means you need to follow the rules of the association. And it's really difficult to challenge if you've, for example, if you've accidentally violated one of the rules of the association. It's not a great defense to say you didn't read the CC&Rs or the rules, or you didn't get a copy. So please, if you can, get a copy of the rules, take a look at them so that you don't accidentally violate any of the rules, because I don't want to get anybody in trouble. I want to try and avoid any problems. The third set of rules are called the rules and regulations. This is a catch-all category of rules in the association. This is where you will typically find rules that come up that can change seasonally. It's a little bit looser. For example, if the association creates a rule about using a common area or a pool or some other community center, about hours and rules about signing up for certain services, that type of stuff you're going to find in the rules and regulations section, because it changes with somewhat, some frequency, and it's not set in stone like the CC&Rs and the bylaws. So you'll find a lot of that day-to-day stuff in the rules and regulations. And then the last set of rules that governs a homeowners association is the Davis-Sterling Act. This is the part of the California Civil Code that regulates homeowners associations. You can think of this kind of like a floor of all the rules. So no matter what the rules of the association are, they have to be in compliance with the Davis-Sterling Act. The HOA can have rules, for example, that are more generous than the Davis-Sterling Act, but not more strict. For example, let's say there's some rule in the Davis-Sterling Act that gives a certain amount. It says that a certain amount of notice must be provided to the homeowners before meetings. And usually, for example, that's 4 days. So the Davis-Sterling Act, the California Civil Code says, here's the minimum amount of notice you have to give people. But if in the bylaws or the HOA governing documents, it gives more time or more notice for that meeting, that's fine. But Davis-Sterling Act lays out the minimum standards for all homeowners associations in California. So all of these rules are something that you have to deal with as a member of the homeowners association. And it's a lot. So if you're in a situation and you need help navigating the rules of your particular HOA and you need some extra help, again, feel free to contact our office. We're happy to set up one-on-one appointments to help you with your individual issues and questions. Okay, next slide, please. So in terms of meetings, I get a lot of questions about being able to attend meetings and the content of meetings. So I want to go over that here. If you're in an association, you're probably familiar with the fact that the board, the HOA board of directors, will conduct relatively routine meetings. Usually the scheduling of those meetings is outlined in the bylaws, but the purpose of the board, the general board meetings, is to discuss the ongoings of the association, for the board to meet and discuss if they're going to hire certain companies or agents, if they're going to address certain issues with the reserve. It's really an opportunity for the board to discuss the ongoing of the HOA and have a discussion before making an ultimate decision. If you're interested in participating or sitting in on those board meetings, they are open meetings, which you can attend, you can sit in on. So you will find the timing and location of those meetings. They are supposed to be noticed at least 4 days before the meeting. Now, it kind of depends on your association, but they might post it in the common area, and so that everyone can see what's going to happen in that meeting. They might send out individual notices or send out emails, or individually let you know in person. But you're supposed to get notice of those meetings at least 4 days before, including a copy of the agenda in terms of the topics that are going to be discussed at that meeting. Now, there are exceptions to that notice requirement. Like I said, if you have something in your HOA's rules that say that the notice needs to be longer, then the HOA should be following that. For example, if they're supposed to give a week notice, they should be giving a week notice according to their individual HOA rules, but at minimum 4 days notice. And anybody who's a member of the association has the right to attend. Now, I have seen in the past where we have homeowners who have rented out their units to tenants, and there are tenants who are interested in participating in these meetings. Technically, the meetings, you only have a legal right to attend if you are a member of the association, meaning one of the owners. However, many homeowners associations allow tenants to attend and participate in the meetings. It just depends on your particular HOA. So in general, I'd say by law, it's really just the owners who have a legal right to attend, but sometimes HOAs allow others as well. And then again, in terms of the topics that are discussed in the general meeting, these are supposed to be outlined in the agenda beforehand. And so it's allowing the homeowners and the general membership to understand what will be discussed at the upcoming meeting. And this is important and comes up sometimes with my office because we have members who have attended a meeting, who want to speak at the meeting and get their individual issues discussed at the meeting. And so what I like to explain to everyone is that the board is only supposed to discuss and deliberate on the items that have been outlined in the agenda. They are supposed to allow the membership an opportunity to be heard and to give their say or their opinion on it. So many HOAs, what they'll do is they'll allot a specific time during the meeting where members can stand up and speak. Usually members are given a limited amount of time, maybe 5 minutes per member, to voice their opinion on that topic. And then the membership is allowed to kind of discuss in that way. Now, sometimes a member may bring up during the session something that wasn't on the agenda. A member can voice their opinion on an item that was even not in the agenda. However, do not expect the board to give an opinion or make a decision on that particular topic if it was not in the agenda. So what a board member may do is the homeowner will approach the board and bring up a particular topic. The board may ask questions, clarifying questions, gather more information, and then at a later date set an agenda topic for a future meeting to discuss it more at length as a board. But in terms of getting some type of answer resolved as a homeowner, you're not going to get some type of decision unless it's part of the agenda. You're probably not going to get a lot of feedback unless it's part of the agenda. So just set your expectations because usually if you want to bring something up in the meeting, likely it's something that's personally impacting you. So what I normally recommend for homeowners, if you've got an issue that you would like addressed by the board, I recommend that you submit a request in writing to the board, letting them know what the issue is, letting them know what your concerns are, and allow that to be the process to get the discussion started with the board about your individual matter. It's very difficult to get some type of resolution or decision at a general board meeting, particularly if it's not part of the agenda. So I just want to put that out there. It's always best to submit your request in writing to the board if you want to have something to be discussed. Next slide, please. Okay, another related question I get is that many homeowners notice that there are these general board meetings that members are allowed to attend. And then sometimes we have homeowners who call and say, this board also has these private meetings that they're not allowing anyone to attend. I want to sit in, I want to participate. Don't I have a right to that? And what I explained is that the general board meetings are open to the general membership. However, the HOA board is also allowed to have what are called executive sessions. And these are sessions that are just meant for the members of the board or any particular individual they invite to that meeting to have private conversations. The topic of the conversations in these executive sessions are for stuff like discussing legal matters of the HOA, if there's individual disciplinary hearings that need to happen for members of the HOA, if there's assessment collection cases that need to be discussed. Those individual private matters are for the board to discuss in an executive session. It's not open and it's meant to be private. So it's not, if you're in an association, the board is not having these secret meetings to try and exclude everybody. It's just that there are specific topics that are meant to be private amongst board's members, and those are held in executive session. Next slide, please. So if you're unhappy with the way that things are happening in your association, my usual piece of advice would be think about running for the board, because the board of directors has a lot of authority to make a lot of decisions for the HOA. It can heavily impact the membership. And if you feel very strongly about what's happening in your association, I really think that you should think about running for the board of directors. The unfortunate thing is there's not a lot of government oversight over what happens in HOAs. And so it really is left up to the individual members to take action and to participate. So if you're interested in running for your board of directors, the first thing is you'll want to check if you're qualified to be a board member, and you'll want to check your governing documents. Usually that information is found in the bylaws. For example, sometimes, in general, almost any member is allowed to run for the board. But for example, sometimes if you're behind on your HOA dues or you have a delinquent account, sometimes you're not allowed to run for a board position if you have a delinquent account. And there can be some other criteria. So just double check your governing documents if you want to see what are the qualifications to be a board member. The other thing that we get asked about in terms of board members is there a way to challenge election results? And yes, any person who had the right to vote in an election, meaning any of the homeowners, has the right to challenge an election. There is a procedure laid out in the Davis-Sterling Act, meaning the Civil Code, that lays out how that's supposed to happen. So if something really went wrong with the election, there are mechanisms in place to allow you to challenge the election. But there's a lot of procedure to it. So it might be helpful to get a little bit of guidance on that if that's something you're thinking about. Next slide, please. The other thing, if you're not interested in participating on the board of directors and you're not entirely sure what to do, but you think that something might be going wrong with your homeowners association, the California Attorney General's office will take complaints about associations in very limited matters. So for example, if your HOA is failing to hold regular meetings, if there's issues with voting or people not being allowed to vote, if the books and records are not being kept properly, or the HOA is not allowing a member to inspect documents of the HOA, that type of governance issue, sometimes you can get the California Attorney General's office to look into that particular matter. They're not especially aggressive on these cases. They don't take them that often, or they don't move on them very quickly, but technically you can make a complaint. I included a link to the website, or if you can't write down this link, I know it's kind of long, you can just Google the California Attorney General's Office Homeowners Association. If you type in that term, California Attorney General's Office Homeowners Association, usually the first page that will pop up is their link to the types of issues that they oversee and the types of complaints they will take. And you can make a complaint there if you have particular complaints. Okay, next slide. The other thing that I think is important for members to know in terms of your participation in the association and the rules and keeping in compliance with the rules is understanding what happens if you accidentally violate one of the rules of the association. So the way it's supposed to work is if you do happen to violate one of the rules of the association, you're supposed to receive a notice of that violation in writing. It's supposed to lay out what rule you violated and basically the basis for that violation. And then there's supposed to be a hearing on that violation where you get an opportunity to defend yourself or bring evidence showing that you weren't in violation. What I like to tell homeowners is if you receive a notice of a violation with the HOA, even before the hearing in the executive session on that violation, ahead of the meeting, I would write a letter to the board. I would, if you have any evidence that you believe shows that you are not in violation, write the letter, attach your evidence, provide any proof you have, and submit that to the board ahead of time. Even though you're not required to, I find it very helpful because you're basically allowing the board to, you're giving them time to review your materials so they're not reviewing it right at the hearing so that they can look at what you have ahead of time and then you can discuss it further in the meeting. If you were accused of doing some type of violation, you're supposed to be allowed to question that individual during that hearing. The only exception, there can be anonymous complaints. If the violation was witnessed by one of the board members themselves, then you don't necessarily get to talk to whoever reported you. But in general, you're supposed to be able to question and ask questions of whoever made the report against you for the violation. Then after the hearing, the board is supposed to send you some type of notice of the decision. So they will tell you if you're, you just get off with a warning, or if the issue is going to be further escalated, if there's going to be some type of fine or penalty, that will be laid out in the notice. And then that notice is also supposed to tell you that you have an opportunity to appeal the decision. So it will probably give you instructions on how to submit an appeal and the time you have to do the appeal. And this basic procedure is just meant to give some form of due process to the homeowner. You're not supposed to accidentally violate a rule and then immediately receive some type of fine or penalty. You are supposed to have the opportunity to defend yourself, have a discussion with the board, and address the issue first before some type of decision is handed down. So if that's not happening, I would certainly reach out and get some additional assistance because you do have a right to defend yourself if you're being accused of a violation. Next slide. Okay, I'm going to spend quite a bit of time on this presentation on assessments because this seems to be the most pressing issue for most homeowners in an association. And so I want to make sure I cover as much of this as possible. So first and foremost, if you are on title to the property, you are the owner of the unit, you are on the hook for assessments that come due while you're on title. If you abandon the property, if you lease out the property, you're still on the hook. You are the one legally responsible for the assessments associated with that unit. Now you might have a separate agreement or in your rental agreement, what have you, that says your tenant is responsible for paying the dues. But in terms of who the HOA can come after, if those amounts are not paid, it's whoever's on title, whoever's the owner of the property. So please keep that in mind. The other thing is that the HOA's right to collect assessments and those procedural pieces, you're going to find that in the CC&Rs and the bylaws, but mostly the CC&Rs. In fact, there's probably a huge section of the CC&Rs just for assessments, the types of assessments, the collection procedures, fines, and penalties. So you should familiarize yourself with those rules. And then I will highlight that paying your HOA dues is just as important as paying your mortgage. I started working at HERA towards the tail end of the recession, and we would get a lot of HOA delinquency calls. And what we were finding is that homeowners didn't realize that just like if you don't pay your mortgage bill, if you don't pay your HOA dues, you can also lose your house to foreclosure. And so what was happening is that homeowners, not realizing the HOA could potentially foreclose, they were just trying to stay afloat, keeping their head above water by paying their mortgage, thinking that they were securing the property by paying their mortgage, not realizing that if they didn't pay their HOA dues, they could still lose the house to foreclosure. So I cannot emphasize this enough. If you're struggling right now, and frankly, it's very tough right now because of the pandemic, if you're struggling financially, it's really important to address any mortgage delinquencies as well as any HOA delinquencies, because they can both have pretty harsh consequences. And I'm going to talk about that further in terms of the process and what your rights are in just a few slides. Okay, next slide, please. So first, let's make sure that everyone understands what types of assessments there can be, because there's a few categories. So the first type of assessments there are regular assessments, your HOA dues. Most people are familiar with these because you pay them on a regular basis. So most HOAs you pay monthly, some HOAs you pay quarterly. It kind of depends on your association, but these are regularly paid assessments. And the amount of the assessment is determined annually. So a very hot topic, I get a lot of calls about this, is an association has increased the regular dues and they want to know if the amount of the increase is legal. So what I explain is that your assessments are not supposed to increase more than 20% of last year's regular assessments. So for example, if last year's regular assessments were $100, which I know sounds very low to some people, especially in San Francisco, if last year's assessments were $100, then this year's increase should be no more than $20. So your new assessment should be no more than $120. That being said, if the membership votes, takes a vote, and everyone has a vote, and there's enough people who vote and approve it, there is a way for the general membership to vote to increase the regular assessments for more than that 20% increase. But there has to be a vote of the membership to do that. So if the board is increasing the monthly or regular dues and it's more than 20%, not okay. However, if the general HOA membership votes and approves an increase in regular assessments that's more than 20%, then it's lawful. So if you're seeing an increase, a significant increase from your previous year's assessments, the first question I usually ask is, was there a special vote on increasing assessments that was held by for the whole membership? And if the answer is yes, then I'd say it's probably legal. The second set of assessments that you might be aware of or concerned about are special assessments. So special assessments are meant to be for unexpected expenses or capital improvements to the association. I frequently will hear of special assessments for stuff like the HOA wants to put a new roof on the association, or some type of new improvement to the common area, or repairs need to be made in each unit for maybe there's some type of heating or duct work that needs to be done. These are improvements that need to be paid for by the association as a whole. Now, they're not supposed to, those special assessments are not supposed to be more than 5% of the annual budget from the previous year. But again, if the general membership votes and says, yes, we want to have a special assessment, and it's more than 5%, as long as there's enough people that approve of it, then it's likely going to get passed and it is lawful. So I'll give an example. I had homeowners, they were in an association that wanted to build a new gym in the communal area. of the association. There were a lot of new homeowners who had moved in, who wanted to do some upgrades to the association. And enough of the new members voted that they wanted these new upgrades. And so this enormous special assessment got passed that everyone was responsible for. And I have seen special assessments as high as $40,000 or $50,000. I know it sounds shocking, but it depends on what needs to be done, what type of capital improvements there are. If there's some significant costs that needs to be handled by the association, these can be enormous individual burdens for the various homeowners. So if you are a homeowner who has limited income and it's very difficult for you to pay for these very large special assessments, in particular, I would strongly recommend that you reach out and get some guidance and some assistance, because it can be very difficult to deal with large special assessments. Unfortunately, there's not a lot of protections available for homeowners in those scenarios. So it's definitely something to keep an eye on. Okay, next slide. The last type of assessment that there can be are called emergency assessments. So these are assessments that require no membership approval, whereas very large increases in special assessment, or excuse me, very large increases in regular assessments and special assessments require a membership vote. Emergency assessments can get passed by the board of directors with absolutely no say from the general membership. But if they're going to pass an emergency assessment, it has to fall within a very specific category. So here are the three categories that it has to fall into if the board can legally pass an emergency assessment. So the first one would be if there's some type of extraordinary expense that's required by court order. The court has said, you association, you need to pay for this particular issue or some type of change in the association or some type of construction. If it's done by court order, the association, the board can pass an emergency assessment. The other one that the board could pass is if there's some type of maintenance required where there's a threat to personal safety, then a special assessment can get passed. For example, let's say there was a fire and now there's, and then it started raining and there's flooding in parts of the association, and there are risks, safety risks to individual members of the association. The board can pass an emergency assessment to charge money to the whole membership to cover the costs of dealing with that emergency. The last category of emergency assessments that can be passed without a vote is if there's some type of extraordinary expense the board could not have reasonably foreseen. If the board is passing a special assessment saying that it's under this category, the board actually has to submit in writing and show and explain why that particular expense was not reasonably foreseen. The board can't just label something as an emergency and then pass an assessment without approval of the membership. So if they're going to use this particular category, they have to explain what it is and why they could not have reasonably foreseen that particular expense. And that's a little bit more difficult for the board to do. It's a little bit higher of a bar or a difficult hurdle for the board under that category. So typically you're not going to see an emergency assessment unless it's either ordered by a court or there's some type of personal safety issue at hand. But like I said, emergency assessments can happen and don't necessarily require a vote of the membership. Next slide. So again, because assessments are really on everyone's mind, especially those special assessments, because they can be very expensive, some of the things that you can do to prepare yourself for the case that there might be a special assessment coming down the line is to do the following. The first thing you might think about doing is reviewing the HOA's financial statements. See what kind of shape the HOA is in. Are there a lot of outstanding debts? Are there very limited reserves? Are there a lot of expenses that are not being covered? see what kind of shape the HOA is in, because if the HOA is not able to cover everything it needs to, there might be a problem and you might expect a special assessment down the road. Another thing that you should probably ask for a copy of is a copy of the budget and the reserve fund. So about once every 3 years, an HOA is supposed to do some type of analysis where they take a look at what shape the HOA is in, if they think there's going to be some expenses coming, if there needs to be some type of repairs done, and they're supposed to do this evaluation to see, okay, how much money do we think we're about to need, or how much money should we be setting aside in order to cover some upcoming improvements or changes to the HOA. And so typically that's done in the reserve fund. They'll do that type of analysis and then provide that analysis to the membership. So if you're curious to see how the HOA is doing, if there's likely going to be some upcoming repairs that are going to be needed, you'd probably find out about that either in the board meetings, because the HOA board might be discussing these matters, or you would find that in the budget and reserve fund. And that can be a good indicator if there's going to be a special assessment, because if there's a lot of repairs that are needed, and I've seen all sorts of things come through the office in terms of big repairs needed from the association and homeowners not wanting to pay, at some point, if the issue is severe enough, or if there's damage to the HOA and it really needs to be repaired, there's probably going to be a special assessment at some point to address it. So take a look at those documents. Like I said, this also might be information that's discussed at the HOA board meetings. So attend the meetings if you can, or review the board meeting minutes, because usually they're discussing these matters during those meetings, and you can get an idea if there's likely going to be some issues in terms of funding, repairs, or addressing these issues down the line. So you can prepare yourself if it's coming. You can ask the board if they're making plans on updating its amenities. For example, are there plans to put in a new gym or a new service in the lobby area? There's all sorts of updates that can be done. Ask the HOA if they're planning on doing any updates to its amenities in the near future, because that's usually going to require some type of assessment. You also, just yourself as a homeowner, can walk around the HOA, take a look at the common areas and the condition of the HOA as a whole. If you're noticing that roofs are looking a little dilapidated, or things are looking really outdated, chances are that there's probably going to need to be an assessment at some point to address the condition of the common areas. So just eyeball it if you can. The other thing is that a few other things you should be checking about is asking about the history of the HOA or the environmental practices of the HOA. If the HOA has either been sued by either members or some other entity and has legal bills to pay, or has violated certain environmental practices and is under scrutiny for that, there's probably some legal bills that might be there that are owed, and that could indicate that there might be an assessment down the line to pay for all of those legal issues. And then finally, talk to your neighbors. Find out what others are hearing about what's happening in the association. Keep yourself informed. Next slide. So if you do find yourself in the position where there has been some type of assessment and you do fall behind, here are the things that you really need to know. So like I said, the association can foreclose if you're behind on your assessments. However, they can only foreclose if you're behind on the assessment portion, not if it's just for late fees or interest or even monetary penalties. It's just if you're behind on your assessments. So if your assessments, if you are less than $1,800 behind on your assessments, or less than 12 months behind on your assessments, the HOA cannot foreclose. The only way the HOA can open up the door to foreclosure is if your assessments that are delinquent are more than $1,800 or more than 12 months delinquent. So for example, let's say that your assessments are $500 a month and you are behind by 4 months, that means you're behind by $2,000, which means you're over that foreclosure threshold of $1,800, and the HOA can attempt to foreclose. There's procedures that I'm about to talk about, but that gives you an idea of how little or how much you might be behind before the HOA might take legal action, meaning foreclosure. They can still sue you for any lesser amounts, but in terms of foreclosure, it's only on the table if your assessments are more than $1,800 behind or more than 12 months delinquent. Okay, next slide. So if that is you, if you are in foreclosure with your homeowners association, this is what has to happen with the association. It's not like they're going to come and take your home tomorrow. There's a very specific procedure. So what's supposed to happen is once you fall behind, the board is supposed to send you a notice saying, hey, you're behind. We acknowledge that you're delinquent. And then what's supposed to happen is the board is supposed to meet and they have a resolution where they say, we think that this person, they're behind, and so we would like to record a lien against the property for those delinquent amounts. Before they record that lien, they have to send you a notice of their decision to record a lien. It's called a pre-lien notice, and they're supposed to send you that notice at least 30 days before recording the lien. And in that notice, it will say something like, if you do not pay your delinquent assessments or your outstanding fees and costs within 30 days, then we will record a lien. The HOA is only allowed to record the lien if you're delinquent on assessments. Again, this is not if you have some type of fine or penalty, if you broke one of the HOA rules. That is not what we're talking about. We're talking about just the assessments. So once the board has decided to record a lien, they send you a notice ahead of time. Then after 30 days, if they're still delinquent amounts, they can record that lien against your property. And that is when they just wait until you've reached that foreclosure threshold of $1,800, or if you're more than 12 months delinquent. So the HOA technically can record a lien after they've sent that pre-lien notice. So you could be as little as 30 days behind. There can be a lien on the property, but the HOA cannot act on it or try and foreclose on it until you're either the $1,800 or 12 months delinquent. So once that happens, if you do reach that point, then the HOA can record what's called a notice of default. That's the first foreclosure notice. This is public record. It gets recorded with the county. It's the first notice that you receive that says, we will move forward with foreclosure if you do not pay your delinquent balance. Then what's supposed to happen is they're supposed to wait at least 90 days before recording the second foreclosure notice. That second foreclosure notice is called a notice of trustee sale. It's that second foreclosure notice where they will tell you the time and date and location of where they're going to auction off the property in foreclosure. Just so you know, that notice is supposed to be recorded at least 20 days before any auction should take place. So if you're following along in terms of math, from the time you get your first foreclosure notice, the notice of default, till the second foreclosure notice, that's 90 days, plus another 20 days until there would be an auction. That's the fastest timeline from the time the first foreclosure notice is recorded. If you can find a way to at least pay your assessments, the delinquent assessments, the HOA is not supposed to move forward with foreclosure. So for example, if you owe assessments and late fees and interest and collection costs, but at least find a way to pay off the assessment portion, the HOA is not supposed to foreclose. However, if you don't pay off the HOA assessment portion, then they can foreclose, and then a foreclosure can take place. In HOAs, unlike with a mortgage, what's unique is even if your house goes to foreclosure and there's a sale, if you can come up with all of the money owed to the HOA, so now we're talking the assessments, late fees, interest, collection costs, if you can come up with the money for everything, then if you pay that within 90 days after the auction, you can get your property back. That is a unique feature of HOA foreclosures. So before the auction or before the foreclosure, you just need to try and find a way to pay off the assessment portion, and then they should stop the sale. Once the foreclosure happens, in order to get the property back, you have to come up with everything, all the money owed, and you have to do it within 90 days of the sale. If you are in HOA foreclosure, please contact our office and get some one-on-one guidance so that you can get some assistance with dealing with that particular timeline. Next slide. So a few questions that come up when you are delinquent. Sometimes people find that the HOA is limiting their ability to participate in the HOA, or they don't get to vote, or they don't get to access certain common areas or facilities. So here's what can happen. If you're delinquent on your dues, the HOA can limit certain activities. However, they're not allowed to limit your ability to come inside the HOA or leave the HOA. They can't limit your access to elevators. They can't limit your ability to attend meetings. They can't impact stuff like trash collection or utilities. There's a limit, but they could limit something like you're not allowed to use the pool or some type of common area like a gym or something like that. They can restrict membership in that way. And again, as it says on the bottom of the slide, the HOAs, some people want to know, if I violate the rules and I have some type of monetary penalty for breaking the HOA rules, can they still foreclose? And the answer is no. Foreclosure is only on the table if you're behind on your assessments. Next slide, please. So here are some rights that you have if you're struggling with dealing with the HOA or if you're behind. The first thing is you have a right to meet and confer with your HOA board. All that means is you have a right to meet with the board and have a discussion with them about your particular issue or about your particular HOA account and try and come up with some type of resolution. The other thing you have a right to do as a member is you have a right to discuss a payment plan. The HOA should provide you with their requirements for payment plans. They have to discuss them with you. It's supposed to be done during an executive meeting. The only thing I will say is this: while you have a right to discuss a payment plan with the HOA, they are not required to give you a payment plan. So while you can ask and try and work with the Homeowners Association to get caught up on your delinquent balance, they're not technically obligated to give you some type of affordable payment plan, which is really unfortunate. So keep that in mind if you're dealing with your HOA. Next slide, please. You do not have to be in a payment plan in order to make payments to your homeowners association. You should not, if you have made some type of payment towards your delinquent balance, that check should not be returned, denied. You should not be told that you have to be in some type of payment plan. By law, you are entitled to make payments on your HOA delinquent balance, and by law, any payment you make is supposed to be applied first towards your assessment portion of the delinquent balance before any other fees or costs. So keep that in mind, because we see a lot of clients who call us and they say, I was required to sign this payment plan agreement to be able to pay my HOA dues, and they made me waive my rights. So now whenever I make a payment, it's first going towards interest and late fees and collection costs before the assessment portion. And I have to explain to people that's unlawful. That shouldn't be happening, and you should please call in for some legal assistance if you're seeing that in your case. Next slide, please. The other thing I like to warn people is if you fall behind on your assessments, it can be very expensive, and here's why. In addition to your delinquent assessments, you might be responsible for paying collection costs from a collection company, which frankly, collection companies can charge hundreds of dollars just for single letters. They're very expensive. You can also be charged a late charge or a late fee of either 10% of the assessment or $10 per month. So for example, if your regular assessment is $300, then you could have a late charge of up to $30 for being delinquent that month. The other thing is that you can also be charged interest on those delinquent amounts up to 12% per year. So when you think about all of those different costs, delinquent assessments can really add up, and you can really get into a really unfortunate situation with the amount owed to the HOA. Doesn't mean that you don't have rights, and it doesn't mean there aren't options available to you. It just means be aware, and it might be helpful to get a little bit of one-on-one guidance if that's the situation you're in. And then I would add, the HOA is not supposed to, while they can charge a lot, they're not supposed to be charging you for costs that they didn't incur. They're not supposed to be trying to make a profit off of homeowners. So that's the other thing to look out for. Next slide. I will say, if you are being charged for something and you do not agree with it, my recommendation would be do not withhold payments. You don't have a right to withhold payments as a homeowner. Rather, you should make the payment, but do it under protest. So if you're being charged something with your check or however you're paying, send it in with a letter that says, I am submitting this payment under protest. If you're sending a check, some people even write paying under protest on the check. What you're doing is you're technically paying it, but you're preserving your right to dispute that particular charge, and in court or however you want to dispute that charge. So if you don't agree, you can pay under protest, but don't withhold payments, because you can just get yourself into a much worse position. I already talked about pre-lien notice requirements, so I'm not going to cover that. So next slide, please. I will say that there are some resources available if you live in San Francisco. So for example, if you have an issue with your HOA and you just want somebody to help you communicate with the HOA or to help you engage in some type of dispute resolution with the HOA, the San Francisco Bar Association has a conflict intervention service that they can help homeowners in the HOA have this type of dispute resolution process. It's supposed to be free. So if that's something you're interested in, I've provided a link to their website, but also here is the number for their helpline, which is 415-782-8940. So again, that's a service provided by the San Francisco Bar Association. And then the other service that's available is if you live in the city of San Francisco, they have the Mayor's Office of Housing has a couple financial assistance programs available. They're called HELP loans, HELP. Their HELP stands for Home Emergency Loan Program. They're loans, they are not grants, but you can reach out to the Mayor's Office of Housing and Community Development if you're interested in applying for one of those emergency loans. They can help with not only delinquencies on your HOA dues, but mortgage delinquencies and some other issues you might be having. So it's something to consider. Next slide. I know that we've just covered homeowners associations, but I just want to highlight for folks, these are all of the services we provide at our office. We have a number of attorneys on staff. Our services are free. The only thing we charge for in our office is if you're doing estate planning, meaning doing a will and a trust or some type of healthcare directive, but all of our debt and credit collections services are free, including any homeowners association issues, collection matters. So if that is you, please, by all means, feel free to reach out to our office. Our telephone number is 510-271-8443, as you can see at the bottom of the slide here. Our intake line is extension 300. So feel free to call in, get a one-on-one consultation with an attorney to talk about your particular issue. This is our website as well, which is the www.heraca.org. Reach out to us. We're happy to help you with your individual matter. And with that, I want to make sure I get to any remaining questions. I know we're going over a little bit in terms of timing. So that concludes the presentation. And now I'm going to go through the question and answer section, answer as many of your questions as possible. I again really appreciate you participating today. And let me just go through here and see what questions you have. So I see a question about special assessments and how much an HOA can levy at one time. As I mentioned, special assessments are not supposed to be more than 5% of the annual budget from the previous year. So it depends on how much the budget was for your HOA the previous year. And if enough people in the association vote to approve a larger increase, that is legal. Okay, let's see. What is required in terms of an investigation of structural integrity of the balconies and overhead stairways under California law? So that's a very complicated question. In terms of associations, they're supposed to, like I said, they're supposed to do some type of survey of the association and see what types of issues need to be addressed. In terms of the structural issues or condition of the HOA, in general, the rule of thumb is if it's part of the outer part of the association, or if it's part of the common areas, that's usually a responsibility of the HOA to maintain and to provide upkeep. If it's an issue that is internal to your unit, that's usually an individual member's responsibility where they take it up with their homeowners insurance company to try and get it covered that way. I see, is it lawful for renters or other non-owners to be members of the HOA board? Typically not. You're usually supposed to be a member and owner of the association. As I said before, the requirements to be on the board are outlined in your bylaws. So you're going to want to check your bylaws for those rules. It says, is the spouse of an owner legally an owner even if their name is not on the deed? So the thing with spouses, I believe there's some rule in Davis Sterling, although I'd have to go back and check. I'm not even sure if this has changed, but typically there are votes available for spouses of legal owners. But that is one of those scenarios where I'd probably need to take a look at your particular scenario and then do a little bit of legal research. But if I'm recalling correctly, I do believe that there are votes available for spouses of legal owners. Looks like we have a question about executive sessions. This question has to do with, are there supposed to be notes done for the executive session meetings? And then there's a question about what does it mean when the note should be generally noted? So in general, what's supposed to happen in an executive session, like I said, usually those are private matters. So you will see notes about generally what happened. You're not going to get detailed blow by blow notes of what happened because a lot of the matters that are discussed in an executive session are private. So there are notes available, but it's not going to be super detailed. I see a question about, let's see. If an HOA continually defers repairs because of concerns about adequate funds, can the HOA claim to have an adequate reserve? So it gets back to assessments in general. If this is a repair that's necessary because it's a safety issue, then there should be some type of assessment passed and covered and the repair should be done. The HOA can't allow the association to be in such disrepair that it's a danger in terms of a personal safety issue. But there are certain repairs or upgrades that are not an emergency, are not a matter of personal safety. And a lot of HOAs do defer those costs because not enough of the membership wants to vote to pass a special assessment to pay for it. So unfortunately, sometimes you will see HOAs push off a lot of those big bills because not enough of the membership is ready to make that type of commitment, financial commitment. It's only really if it's an emergency or a matter of personal safety that you're going to see a requirement in a big bill that doesn't necessarily get approved by the membership. Is a special assessment $10,000 levied to each owner, or is the amount spread out over all members? That's a good question. So the way special assessments work is usually there's one large bill that's owed, and then what will happen is the association will send out a notice of what your pro rata share or your individual share of that special assessment will be. It kind of depends on what the special assessment is for. If, for example, it's for certain types of roof repairs or something that like square footage would be appropriate, the association might decide to split that cost based on the size of your unit. So people with larger units might have to pay a little bit more, whereas someone with a smaller unit would pay less. A lot of special assessments, they just divide the bill evenly amongst all the homeowners. But when I mentioned the example of a $40,000 or $50,000 assessment, that was the individual portion for that homeowner because it was such a massive repair that was being done, almost to the point where it was a little questionable. But I have seen very, very large special assessments for individuals. It says, how do we know if HOA is being honest about assessments and not pocketing the revenue or splitting it between board members? So this gets back to asking for the financial statements of the HOA and the budgets. You have a right to documentation from the Homeowners Association. You have a right to get copies of that documentation. And if you think that there's something underhanded happening, you can always make a complaint to the Attorney General's office, as I mentioned. I see a question about if we seek legal assistance against an HOA, can we contact your office? Or there are attorneys who specialize in dealing with HOAs? It depends on what the issue is. Our office tries to spend most of our time helping folks who are in foreclosure or are at risk of losing their homes. That's just part of the mission of our office. We don't tend to take on big cases around structural integrity of the whole HOA building, but we can provide referrals if you'd like. So if that's something you're concerned about, it depends on what the legal issue is, but you can call our office for a referral if you need one. Okay, it says HOA, your HOA recently raised the dues by 20% after several years of no dues. And then it says board has taken over after a period in which older residents had dominated the board and refused to raise the dues. And now older residents of the HOA are now threatening to sue the board for age discrimination. So I'd need a little bit more detail about this particular scenario in terms of the back and forth because it has to do with discrimination. So this is one of those scenarios where I'd recommend calling to our intake line, get a one-on-one consultation. That would be, I think, easier for me to answer that particular question. Okay, regarding HOA minutes, can the requirement be made? So if I'm understanding this question correctly, there's a question about HOA minutes. So oftentimes meetings are recorded and then those recordings are noted into written notes or written minutes. So recordings are deleted and not usually available to the membership, but you do have a right to get a copy of the minutes, the actual paper records. As a member, you're entitled to get a copy of those minutes. So if you're having an issue